Welcome to the Deep Dive. Today we're tackling something pretty fundamental, how land ownership actually works in South Africa.
Yeah, it's a big one.
We've pulled together a really diverse set of sources for you.
Yeah.
I mean, everything from the historical laws that, laid the groundwork.
All the way through to the key court cases that have shaped how we understand property rights today.
Exactly. And the current legal principles governing who owns what, how it changes hands. Our goal is really to cut through the complexity and bring you the key insights into buying, selling, even, contesting land ownership. You might find some surprising things along the way.
Definitely. If you've ever wondered about the ins and outs of land here, well, you're in for a fascinating trip through history and the legal system.
Right.
It's not just about dusty old laws. It's about understanding how that past still has, a very real impact right now.
Think of this as your express route to getting informed on a topic that really touches everyone without getting totally bogged down in legal jargon. So just to give you an idea of how deep we're planning to go, we're looking at foundational laws like the Natives Land Act, the very basis of land segregation under apartheid.
The critical starting point.
All the way through to the post-apartheid reforms, things like the Restitution of Land Rights Act. We'll also dig into the practical side.
Like the Alienation of Land Act, the Deeds Registries Act, the nuts and bolts of buying and selling.
And crucially, those pivotal court decisions. Names you might hear are Sebetana v. Van Jena, Pasha v. Southern Metropolitan Council, Mackay v. Vodacom.
Yeah.
Loads of them that have clarified and sometimes even challenged the written law.
Yeah, you really can't talk about land ownership in South Africa without confronting the profound legacy of apartheid. It's just unavoidable.
Absolutely.
For decades, you had these discriminatory laws systematically dispossessing non-white South Africans, that 1913 Natives Land Act, for instance.
Yeah.
It restricted African land ownership to just a tiny fraction of the country. Initially, what was it, only 7%? Later increased to a still, paltry 13%. Black people were basically banned from owning or even living on land outside these tiny areas, except maybe as laborers.
So the vast majority of the country was just reserved for the white minority.
That's right. And in urban areas, it wasn't even about title deeds for Black South Africans. Often they got residential permits, sometimes just for 30 years initially.
Right. Later, maybe 99-year leaseholds, but not full ownership.
Exactly. So by 1991, just as apartheid was starting to dismantle, something like 87% of the land was owned by white people.
87%. Wow.
The Abolition of Racially Based Land Measures Act in 91 was a critical turning point. It finally repealed a lot of that discriminatory stuff and paved the way for the land reforms we see now.
Okay, so that brings us to the post-apartheid era. Let's dive into those reforms.
Right. So after 1994, the new Constitution brought in Section 25, guaranteeing property rights, but importantly, it also committed the state to achieving equitable access to land.
Through land reform programs.
Exactly. There was this understanding that just repealing the old laws wasn't going to be enough, You had to actively try and fix the inequalities created by decades of those policies.
And that led to things like the Restitution of Land Rights Act.
Yes, that was about compensation or getting land back for people dispossessed under apartheid.
And then redistribution and tenure reform.
Yeah, those involved grants to help people buy land and also efforts to make tenure more secure for people already living on land, maybe informally.
There was also the Upgrading of Land Tenure Rights Act, wasn't there?
Yes, that was particularly interesting. It was designed to automatically convert many of those old homestead permits held by Black occupiers into full ownership.
But there's a catch, right?
There is. There's a big ongoing challenge, actually. SCR, the Socioeconomic Rights Institute, has brought a constitutional case.
Okay.
They're highlighting how the act often converted a permit held only by the husband into his full title, effectively just, cutting wives out of ownership.
So perpetuating past discrimination.
Exactly. A clear example of how those old systems can still create inequality today, even with reform laws.
Which leads us nicely into another really crucial piece of legislation, the Conversion of Certain Rights into Leasehold or Ownership Act, Act 81 of 1988.
Right. This one specifically targeted those apartheid-era site permits, the kind you found in townships under things like the Group Areas Acts.
And the goal was to change these insecure rights into something more solid.
Yeah, into registered leaseholds or even full ownership. Section 2 of the Act set out a process. An administrator would investigate specific permit types, like those under Regulations 6 and 8.
And if that went well?
They'd issue either a leasehold or full ownership title to the permit holder. But, and this is important, ordinary residential permits, often called Regulation 7 permits, were treated differently.
How so?
Section 6 of the Act said those automatically became unregistered statutory leases. The courts confirmed this in the Sabatana v. Mangina case.
So not all permits got the same treatment. Some became ownership or registered leaseholds, others just unregistered leases.
Precisely. So the key takeaway is, the type of permit you held really mattered for the outcome of that conversion process.
Okay, so if someone had one of those Red 6 or 8 permits and the administrator approved the conversion, what was the next step to actually, get the title?
The administrator would issue a certificate, and that certificate then had to be taken to the registrar of deeds. That's how the new lease or title got officially recorded.
Was there any way to challenge the administrator's decision?
Yes. Section 3 of the Act allowed for an appeal if someone thought the conversion was wrong.
And that registration step, how important was it?
Oh, massively important. The Pasha v. Southern Metropolitan Council case really drove this home. It highlighted that if the authorities failed to actually register a converted right,
Yeah.
that failure, that inaction, could potentially be seen as a debt owed by the state.
Yeah.
And debts can expire under prescription laws.
Right, prescription, like a time limit. But didn't the McCotts v. Vodacom case kind of refine that idea, especially for things that aren't just about money?
It certainly did. While Pasha suggested this duty to register could be a debt, the Constitutional Court in Makate made it quite clear that prescription shouldn't be used unfairly to block claims that aren't purely about money.
Especially if it leaves someone with no way to get a remedy.
Exactly. So it added this layer of nuance. You have to look at the specific claim and whether prescription would lead to an unjust outcome.
Okay, so Pasha raised the prescription issue for registration, but Makati said, hang on, let's look at fairness, especially for non-monetary claims. Makes sense. Now, you mentioned ongoing constitutional challenges. Tell us more about Mathlami v. Mamain.
Yeah, this is a really significant case. It's currently before the courts. SCRI is challenging parts of both the Conversion Act and the Upgrading Act.
On what grounds?
The core argument is that these laws are still effectively perpetuating gender discrimination rooted in the apartheid era.
How?
Well, a key example is where a permit was issued back then only in the husband's name, designated as the head of the family.
Right, a very common practice.
So the automatic conversion under these acts often transferred ownership only to him, completely excluding wives, leaving them with no recognized land rights at all.
Wow. So the law, trying to fix one problem, inadvertently cemented another inequality.
That's the argument. It really shows how the effects of past discrimination can just linger and why ongoing legal scrutiny is so vital to achieving, genuine land equity.
It's a stark reminder, isn't it? Changing laws on paper isn't always enough. You've got to look at the real-world impact. Okay, let's shift from conversion to the basics of actually buying and selling land today. What are the absolute must-know legal steps?
Okay, so when it comes to selling land in South Africa, the Alienation of Land Act 68 of 1981 lays down some very, very strict rules.
Yeah.
Section 2.1 is key.
What does it say?
It states very clearly that any sale of land must be in writing. It has to be in a deed of alienation.
A written contract.
Yes, and crucially, it must be signed by both the buyer and the seller or their legally authorized agents.
Both parties have to sign.
Both. The only exception to this very firm rule is land sold at a public auction. That's different.
So no verbal agreement for land sales? A handshake deal doesn't count?
Absolutely not. No matter what promises are made, if it's not in writing and signed by both parties as the act requires, it means nothing legally when it comes to selling land.
And if you don't follow these rules, if you just have a verbal agreement?
The act is crystal clear. The agreement is considered of no force or effect. Basically, it's void from the very beginning, void ab initio. The MDV-BD case illustrates this point well.
Void. So it's as if the agreement never even existed in the eyes of the law.
Exactly. So the crucial insight here for anyone listening is, in South Africa, a handshake deal for land is legally worthless. It must be in writing and signed by both buyer and seller, period.
That sounds incredibly strict.
Yeah.
Is there any way back if you, say, paid a deposit based on a verbal agreement that turns out to be void?
Well, Section 28 of the Act does offer some relief there. It allows parties to claim back any money or property that was exchanged under an agreement found to be invalid because it didn't meet those formalities.
Okay, so you can potentially get your money back.
Yes, while the agreement itself is dead in the water, you're not necessarily left completely empty-handed if you've already performed, like, paid money.
That's good to know. What are the absolute essential details that have to be in that written contract for it to be valid?
Section 6 of the Act spells this out. A valid written contract needs the full names and addresses of both the buyer and seller.
Okay.
A clear, unambiguous description of the property, usually the OIF number, maybe the street address, enough to identify it precisely.
Makes sense.
The agreed purchase price, obviously. If there's interest involved, the rate of interest, and if it's being paid in installments, the details of those payments.
All that has to be there.
Yes. Without all these essential terms, even a written and signed document might be deemed unenforceable. It's also worth noting the Act specifically covers sales contracts. Other kinds of transfers, like if a court orders a transfer in a divorce settlement, or transfers resulting from a property subdivision, those aren't technically alienations under the specific Act.
Okay. What if a buyer is paying in installments, and they've paid off a really significant chunk, say more than half, but the seller is just dragging their feet on the transfer? Does the buyer have any power?
Yes, absolutely. Section 27 of the Alienation of Land Act deals with exactly that. If a buyer has paid at least 50% of the purchase price in installments,
50% or more.
they have the right to demand transfer of the property. They just need to give written notice to the seller.
Okay, they can force the issue. Is there a time limit on doing that?
Yes, there is. Any legal action to compel that transfer under Section 27 must be started within 3 years from when the right to claim transfer arose. Usually that's linked to when the required payments were made.
3 years. That's important to remember.
But here's a crucial distinction we need to make clear. These formal requirements for a valid sale agreement under the Alienation of Land Act are separate from the process of actually transferring ownership.
How so?
If the initial sale agreement wasn't in a correct written form, wasn't signed by both parties, it's just void from the start. It's not simply a claim that expires after 3 years like the Section 27 claim might. The MDV-BB case really hammered this lack of form makes the sale void, period. It doesn't just become subject to prescription.
Got it. The sale agreement itself has to be legally sound from day one. Okay, now let's talk about what actually makes you the legal owner of land in South Africa. How does that happen?
Right, South Africa uses what's called an abstract system of ownership transfer. This is a really, really key concept.
Abstract system. Okay.
Unlike some other legal systems where signing the sale agreement might be enough, here, ownership of land only officially passes when the transfer is registered in the deeds office.
Registration is the key moment.
It is. Think of it like the final delivery confirmation. That registration confirms the change of ownership, and legally it's considered separate or abstracted from whether the underlying sale contract itself was perfectly valid or not.
Wait, so even if there was a flaw in the original sale agreement, registering the transfer could still make someone the legal owner?
Generally, yes, that's the core idea of the abstract system. What's required for ownership to pass is a valid, real agreement.
Real agreement.
Yeah, it basically means both the seller genuinely intended to transfer ownership, animus transferendi, and the buyer genuinely intended to receive it. Plus, you need the delivery, which for land means registration at the deeds office.
So intention plus registration.
Exactly. The courts have said the underlying reason, the causa or sale agreement, doesn't necessarily have to be flawless at the exact moment of registration. So if a buyer registers the property in good faith, believing they have the right to,
They usually become the legal owner.
yes, generally they do, even if it later turns out there was some defect in the sale agreement that came before it.
That's quite a powerful system for registration. But surely there are exceptions. What if the whole transfer was based on, say, fraud?
Ah, fraud. That's the major exception. If the seller never truly intended to transfer ownership, maybe their signature was forged on the transfer documents, or they were forced to sign under duress,
Okay.
then that crucial element, the genuine intention to transfer, the animus transferendi, is missing.
No real agreement then.
Precisely. In those cases, the registration, even though it's happened, can be challenged and set aside as invalid. The Nedbank v. Mendelow case is a prime example.
What happened there?
A son fraudulently got his father's property registered in his own name without the father's genuine consent. The court ruled that transfer and a subsequent mortgage the son took out were void because the father never actually intended to transfer ownership.
So registration isn't absolute if fraud vitiates the intention. What can someone do if they've been a victim of a fraudulent transfer?
They have several legal options. They can seek rescission, basically asking the court to undo the transfer and put things back the way they were.
Get the property back.
Yes. They can also pursue restitution, which is about getting compensation for any financial losses suffered due to the fraud. And there's also Section 34 of the Deeds Registries Act, which provides a specific way to apply to court to have a fraudulent deed canceled.
Okay. Now, going back to those invalid sale contracts we discussed earlier, the ones void for not meeting the Alienation of Land Act formalities,
Yeah.
how do they fit with this abstract transfer system?
It's a good question. It's vital to understand that a sale contract that's void from the start, because it wasn't written and signed correctly, never actually creates any legal obligation to transfer ownership in the first place.
Right, because it's legally non-existent.
Exactly. So in practical terms, a seller can't legally transfer title based on such an invalid contract unless maybe a court somehow orders it, and courts are extremely unlikely to do that if the basic requirements of the Alienation of Land Act weren't met.
So even with the abstract system focusing on registration,
If there was never a valid underlying sale agreement to begin with, any subsequent transfer is potentially vulnerable. It could be challenged, especially if the lack of a valid contract is proven in court. Registration based on nothing valid is shaky ground.
okay, that clarifies the link. Let's switch gears again. How else can ownership change hands? Let's talk about prescription. We touched on it with Pasha.
Right, prescription. As laid out in the Prescription Act of 1969, it plays two main roles regarding property. First, there's acquisitive prescription.
Gaining ownership through possession.
Exactly. This is where someone can actually become the legal owner of land just by possessing it openly, notoriously, meaning not secretly.
Like everyone can see they're there.
Yes, and acting as if they are the owner continuously for 30 years, and crucially, without the actual owner's permission.
30 years of open possession as owner.
That's the magic number. It's considered original prescription because the new title doesn't rely on the previous owner's consent. After that uninterrupted 30-year period, the law basically says, okay, you've acted like the owner long enough, you now are the owner.
So someone could squat on land openly for 30 years and legally claim it.
If they meet all those strict conditions open, notorious possession, acting as owner, continuous for 30 years without permission, then yes, in principle. The second role is extinctive prescription.
This is about time limits for claims.
Yes, limiting the time you have to bring certain legal claims. Generally, for contractual claims like a buyer trying to force a seller to transfer property based on a valid contract, there's a 3-year time limit from when the claim arises.
And this loops back to Pasha and Makati.
It does. Remember, Pasha suggested the failure to register a converted lease could be a debt subject to that 3-year prescription. But then Makate clarified that we need to be careful about applying prescription too rigidly to non-monetary claims, especially if it denies a remedy unfairly. So, in the property context, if a buyer has done their part, paid the price, or at least 50% under Section 27, but the seller delays transfer, the buyer generally has 3 years to sue, unless maybe Section 27 gives them specific extended rights.
What about the original owner trying to get their land back? Say, from someone who hasn't been there 30 years yet. Is there a time limit on the owner suing to recover their property?
That's the re vindicatio action. It actually has a much longer prescriptive period. While claims for movable goods might prescribe in 3 years, the fundamental right of an owner to claim back their land doesn't just disappear after 30 years. Ownership itself is a very strong right.
Okay, so the owner's right to recover the land persists much longer. Good to know. Now, another way ownership can change, often in difficult situations, is through a sale in execution. Sheriff sale. What protections exist there?
Right. A sale and execution where the sheriff sells property to pay off a debt confirmed by a court judgment obviously has huge implications, especially for constitutional rights like property, Section 25, and housing, Section 26.
Particularly if it's someone's home.
Exactly. The Constitutional Court recognized this. They ruled that selling someone's primary home without proper judicial oversight could be an unfair violation of their right to adequate housing. The Jaffa v. Shulman and Gunwana v. Stecco development cases were absolutely pivotal here.
What did they establish?
They established that courts must supervise the process when a creditor wants to execute against a person's primary residence. Fairness and equity demand it.
So a bank, for instance, can't just automatically auction off your home if you fall behind on mortgage payments. There's a court check.
Precisely. Following those cases, the uniform rules of court were changed. Rule 46A now specifically requires a court hearing before a person's primary residence can be sold in execution.
And what happens at that hearing?
The judge has a crucial role. They need to confirm if it is the debtor's primary home. And very importantly, they must explore if there are other, less drastic ways to settle the debt that wouldn't involve selling the person's home.
Trying to avoid homelessness, basically.
That's a key consideration. It's a vital protection for vulnerable homeowners.
Does this apply universally? What if it's a company property being sold?
That's an important distinction made in the Sigalo v. Botha case. The court clarified that this mandatory judicial oversight, this high level of scrutiny, is primarily for sales of individuals' primary residences.
Not company assets.
Generally, no. Properties owned by companies, perhaps being sold during liquidation, don't get quite the same level of constitutional housing protection under Section 26 in this specific context. The focus of Rule 46A is really on safeguarding individual homes.
That's a key difference.
Yeah.
Okay, let's move to co-ownership. When more than one person owns a property together, what does that involve legally?
Co-ownership is basically where two or more people hold undivided shares in a single property. Each co-owner generally has equal rights to use and enjoy the whole property.
Undivided shares.
Yeah,
Meaning you don't own, like, the north half and they own the south half?
exactly. You both own the whole thing together, just in specific proportions or shares. Unless there's an agreement stating otherwise, spouses married in community of property usually own equal shares. Other co-owners might agree on different shares, or if they don't agree, it's often presumed to be equal shares too.
What if one co-owner wants out? Maybe they want to sell their share or just end the whole arrangement. How does that work?
Any co-owner generally has the right to end the co-ownership. There's a specific legal action for this called the Actio Communi Dividundo.
A what now?
Actio Communi Dividundo. It's a lawsuit asking the court to partition the property.
Partition. Like physically split it.
Well, yes, if that's practical.
Yeah.
But often, especially with a house, you can't just draw a line down the middle. So more commonly, the court will order the property to be sold.
Sold on the open market.
Yes, and then the money from the sale is divided between the co-owners according to their shares. The PNVAE case is an example where this happened in a divorce because the family home couldn't realistically be split.
So the court steps in to break the deadlock, essentially.
Yeah. Exactly. If division isn't feasible, sale and division of proceeds is the usual route. However, there's an important nuance here, highlighted in the Municipal Employees Pension Fund v. Crystal Investments case.
Which is?
The court distinguished between free co-ownership and bound co-ownership.
Free versus bound.
Free co-ownership is where there's no underlying relationship tying the owners together, maybe just two friends who bought an investment property. Bound co-ownership arises from a specific relationship, like marriage and community of property or a business partnership, maybe beneficiaries of a trust.
And why does that distinction matter?
It matters for when you can demand termination. The court said free co-ownership can generally be ended at any time using that actio we mentioned. Anyone can just say, I want out.
But bound co-ownership.
That usually lasts as long as the underlying relationship exists. For example, spouses married in community of property have a bound co-ownership. You can't just demand partition while you're still married.
It only becomes free once the relationship ends.
Exactly. Once the marriage ends through divorce or death, then the co-ownership becomes free. And if needed, partition can be sought. Though usually, dividing the house is handled as part of the divorce settlement itself.
Got it. The relationship dictates the timing for ending the co-ownership.
Yeah.
Okay, let's shift focus one last time. Lease agreements. Renting property. What are some key things landlords and tenants in South Africa should know?
Okay, leases. They can be formal written contracts or even informal verbal ones sometimes, but there are specific rules, especially for long leases.
Like what?
According to the Deeds Registries Act, if you have a lease of land for more than 10 years, it must be notarially executed.
Signed before a notary public.
Yes. And it must be registered in the deeds office to be fully binding on third parties, like a new owner, if the landlord sells the property.
So registration protects the tenant in a long lease if the property is sold.
Correct. For leases shorter than 10 years, verbal or simple written agreements are generally fine. But you can't cheat the system by having, say, 2 consecutive 6-year leases to avoid registration.
Makes sense.
Yeah.
What about basic rights and duties? Landlord versus tenant.
Both have reciprocal duties under common law and also various laws like the Rental Housing Act and the Consumer Protection Act. The landlord generally has to keep the property in a livable state.
Maintain it.
Yes, essential repairs, roof, walls, plumbing, heating. They also need to ensure the tenant has peaceful, uninterrupted use of the place.
And the tenant.
The tenant's main duties are paying rent on time, using the property only for agreed purposes, not damaging it or letting it fall into disrepair beyond normal wear and tear,
Right.
and returning it in good condition at the end of the lease. Statutes add more detail, like rules about rent increases, deposit handling, and, importantly, proper eviction procedures. You can't just kick someone out.
Fair legal process is needed.
Absolutely. And clauses in a lease trying to completely remove a landlord's duty to maintain the property would likely be invalid as against public policy.
Okay. You also mentioned something earlier, a landlord's tacit hypothec. Sounds complicated.
It does sound a bit archaic, doesn't it? But it's a real thing. It's a common law security right. If a tenant falls behind on rent, the landlord automatically gets this tacit hypothec. It's basically a legal claim or lien over the movable property the tenant has brought onto the leased premises.
Automatically, just by the rent being late.
Yes, it arises automatically the moment rent is overdue. But, and this is crucial, that initial hypothec isn't yet a full, real security right.
What does that mean?
It means the landlord can't just seize the goods yet. To properly enforce it, to get the right to actually prevent the tenant removing those goods or to sell them to cover the rent.
They need to do something else.
Yes. They have to go to court, get an order, and have the sheriff of the court formally attach the specific movable goods on the premises. It's only after that attachment that the landlord gets a proper, enforceable, real security right over those goods.
So a landlord definitely cannot just lock up a tenant's stuff themselves if the rent is late. No self-help.
Absolutely not. That's illegal. And furthermore, if the landlord doesn't take steps to perfect the hypothec, get the court order and attachment within 3 months of the rent default, the hypothec actually expires.
3 months.
Yes. The Ergamode v. Jordan case really emphasizes this. The hypothec is just a personal claim until perfected by judicial attachment. In that case, the landlord hadn't perfected before the tenant company went into business rescue, so they lost out.
So the takeaway is, the hypothec exists, but landlords must use the courts to enforce it and do so promptly.
Exactly. It's vital for both landlords and tenants to understand that process.
Okay, final topic. Preemptive rights, sometimes called a right of first refusal. What's that about?
A preemptive right basically gives a specific person the first crack at buying a property if the owner decides to sell.
So the owner has to offer it to them first.
Yes. Before offering it to anyone else on the open market, they're legally obliged to offer it to the holder of the preemptive right, usually on the same terms they'd be willing to accept from a third party.
How did the law view these historically?
Well, for a while, South African courts often treated them as a kind of agreement to sell, which meant they thought these rights needed to meet the strict signing formalities of the Alienation of Land Act written, signed by both parties.
Like a mini-sale agreement?
Sort of. This created uncertainty, especially if a lease extension included a preemptive right. Did both landlord and tenant have to sign that extension for the right to be valid?
But the Constitutional Court stepped in.
Yes, thankfully. The Mokone v. Tassos Properties case brought much-needed clarity. The Concourt ruled that a preemptive right itself is not a contract of sale.
It's not.
No. It's an agreement about a potential future sale, but it isn't the sale itself. Therefore, it doesn't need to meet those strict Alienation of Land Act signing formalities right from the start when the right is granted.
So how does it work then when the owner wants to sell?
When the owner decides to sell, they just need to make a proper written offer to the person holding the preemptive right. They have to give that person a reasonable chance to decide if they want to buy on the proposed terms.
And if the holder says, yes, I want to buy,
they need to accept that offer in writing. At that point, then, a binding sale agreement comes into existence. They effectively step into the shoes of the potential buyer. The Concourt in Mokone stressed that enforcing the right just needs that proper offer and written acceptance. You don't need a separate, fully signed sale contract at the moment the right is exercised.
So Mokone made enforcing these rights simpler, clarifying they only become sale contracts upon acceptance.
Exactly. It removed that earlier confusion about formalities.
Wow. Okay, well, this has been an incredibly comprehensive deep dive into the, let's face it, intricate world of land ownership in South Africa. We've covered a massive amount of ground.
We certainly have.
From understanding the enduring impact of historical laws to the ongoing land reforms.
The absolute critical need for legal formalities and transactions.
The unique abstract system of ownership transfer we have.
The constitutional protections around housing.
And then co-ownership, leases, preemptive rights.
Yeah, it's a lot. For me, one of the really striking things is just how deeply that legacy of apartheid continues to echo through the legal landscape today. It drives
Yeah.
so many ongoing challenges and reforms.
Absolutely.
And I think that abstract nature of ownership transfer is particularly interesting how much weight registration carries, sometimes even separate from the initial sale agreement's validity. That and maybe the specifics of perfecting the landlord's hypothesis, that's probably not common knowledge.
Definitely not.
Yeah.
So for you, the listener, we really hope this deep dive is giving you a solid foundation for understanding property rights and transactions here.
Mm.
Whether you're dealing with property personally, need this for work, or are just curious about this, frankly, fascinating area of law.
We've tried to give you that structured overview without hopefully drowning you in too much detail.
Right. And as you think about everything we've discussed, maybe you consider that ongoing balancing act in South African land law.
Trying to address those deep historical wrongs while also protecting current property rights. It's not easy.
Perhaps reflect on which bit of this complex legal puzzle you find most compelling or, what raises the most questions for you.
Because it really is a constantly evolving area of law. There's always more to dig into, always more to understand.